Next, the principle of non which animates art applies a fortiori in regard to the manner in which sitting and former judges of the High Court are irrespective of the drawn. So this principle of non was under the decision of this court in P. Ramakrishnan versus Union of India, 2014, 12 SCC 1, page 1. मिलेगा 22 में page 7 DD page 7 8. This was recent. The decision of this court in Union of India versus Justice Retired Raj Rahul Garg, 2024, INSC 2, where the court held EE in note. Above all, the locus classicus on the subject is the India Judges Association versus Union of India, 2024 to 26, where it has been the interrelationship between judicial independence and finance has been illustrated in the following terms. Down at 14 F. This leaves the court of interpreting Section 20, 1954. Section 20 stipulates that every judge shall be entitled to the General Provident Fund, its services. The expression mandatory any exception. What the proviso does, a person, it is to deal with the case of a judge who has held any other pensionable civil post under the union or a state. In terms of the proviso, to subscribe to the Provident Fund, the judge was subscribing before appointment as a judge. So, properly construed, the proviso was not intended in nature. Full stop. It is well settled that to be treated as an exception or in the nature of an explanation to the main provision. Full stop. The proviso in the present case is more in the nature of an explanation, so as to allow a judge who holds a pension under the union or a state and who is subscribing to continue to do so even after appointment as a judge of the High Court, so as to ensure that the benefits would not be disrupted. The Attorney General placed reliance on the provision. Don't say though. The Attorney General place reliance on the provision that judges were appointed after 1 April 2004 pension scheme. Full stop. At this stage, I clarify that in the course of these proceedings, we are not adjudicating in any manner on the issue of the applicability of the new, on any the applicability or the validity of the new pension scheme. Necessity to issue this, that issue is pending before this court in independent proceedings. The simple issue before the court is as to whether a member of the district judiciary, upon appointment as a judge of the High Court, would be entitled to the benefit of the General Provident Fund, which is available to all High Court judges under full stop. Unlike the payment of pensions, where we noticed, there are different provisions in sections 14 and section 15. Inter alia, sections 14 and 15 of chapter 1954. There is only one in regard to the payment of Provident Fund, which is contained in section 20. The proviso to section 20, even if it is to be treated as an exception, would have to be strictly construed, and so construed would have no application to the facts of the present situation. Full stop. It is not in dispute that members of the district judiciary appointed after 1/4/2004 did not subscribe to any provident fund, in which there was no question of applying the proviso to deprive them of the benefit of the General Provident Fund, which is available under the substantive part of section 20. For the above reasons, the conclusion. Courts, institutions, and upon appointment as judges of the High Court, all judges partake of the character of the holders of constitutional offices. Semicolon. Bracket 2. 221 of the Constitution, Article 221, bracket 2, neither Article 200, bracket 2, neither Article 221, bracket 1 of the Constitution, which empowers Parliament to determine the salaries of the judges of each High Court, nor Article 221, bracket 2, which empowers Parliament to and rights in respect of the leave of absence and pension, contemplates that a discrimination can be between judges of the High Court based on the source from which they are drawn. 3. Article 200 of the Constitution specifies distinct sources of recruitment for judges from the district judiciary, or as the case may be, the bar. But once appointed to the High Court, all judges form one constitutional office holders. 5. The importance which has been ascribed by the Constitution stems from the rationale that there is an intrinsic relation between independence and judicial independence. The provisions pertaining to the guarantee of silent service, post-retirement benefits for judges is amplified by the salaries and allowances of sitting judges and the pension as a charge, respectively, on the consolidated fund of the state and the consolidated fund of India. 7. Any determination of the service benefits of sitting judges of the High Court and the pensions which are payable to them and the retirement benefits which are payable to them must take place on the basis of the non-discrimination. One home. 8. Court. It is the source from which they are drawn, performed on, are entrusted with the same duties of adjudication, the law. Full stop. Once appointed as judges of the High Court, their birthmarks stand obliterated, and any attempt to make a distinction is either for the purpose of determining their conditions of service while in service or any form of retiral dues would be unconstitutional. Full stop. The letter which was addressed by the communication by the Deputy Accountant General, by the Minister, by the Undersecretary to the Government of India and the Department of Justice, purportedly stated that as judges appointed by direct recruitment to the state judicial service after adoption of the NPS by the state governments and subsequently appointed as High Court judges are covered by the contributory pension scheme state government, they would not be eligible to subscribe to fund. The letter is clearly based on a misappreciation not only of the statutory scheme underlying 20 of the Act of 1954, but is fundamentally at odds with the constitutional status of all judges of the High Court, irrespective of the source from which they are drawn. The letter dated 30 December 2022 shall accordingly stand quashed and set aside. In consequence, we allow the petition by directing that a judicial account shall be opened with effect from the date of every one of the petitioners, into which contributions shall be credited at par with all other judges of the High Court, irrespective of the source from which they were drawn. We are not at this stage issuing a direction, though it was sought in the petition, for the transfer of the contributions lying in the new pen under the to the General Provident Fund, since the entire issue in regard to the entire issue in relation pending before this court for independent of these proceedings.
It should be returned, my lord. It should be returned to the judges.
Shall, however, be returned to the petitioners with the
contribution, Manoj, whatever is lying in the NPS
It is
account,
there.
they will
what the amounts which are due of the to the petitioners in the of the account holder petitioners shall, however, be returned to them within a period of 4 weeks from the date of this judgment.
That is their contribution.
Whatever is lying in the account,
No.
The whole
What they have
the
contributed.
entire amount. I mean,
They have contributed.
whatever is lying in the account.
No.
To put in something.
Yes, that's what I'm saying. It is their contribution, it will go to them.
because then I'll tell your lordship, then what it is.
No,
Because
no,
the
that's a
so
problem.
that at least address the court. Sir.
Yes.
I'm saying the Attorney General first argue that it can't be shifted to the GBF account. Now, what will happen is if you withdraw the whatever interest it has accumulated on that will completely.
We are not saying that the government's contribution will be.
He's asking, the learned Attorney General is saying only
No.
judges' contribution should go back. If the government's contribution to the NPS is withdrawn, then what happens is the judges from the district judiciary for 30 years, for 15, 20 years, whatever
They have accumulated. No.
So whatever
They have
lying-
accumulated 30.
So whatever is what we originally dictated is correct. The back account must be returned.
The account must go back. Not just the contribution, whatever is in the balance in the
Balance of the account.
Two contributions.
But
Their
it's an
contribution-
account, right? It's a
That is
balance means
whatever they have
the
contributed.
bottom line.
No, I have a problem there. Whatever they have contributed.
Or government's contribution.
No,
It's a fungible contribution.
Can't be again split up and
You can't have a pension money given to them as a contribute as a provident fund today. Whatever they have contributed, will go back to them.
No, we are not saying give it to their provident fund account.
No,
We are
whichever
saying
account.
return it
Even-
to
no,
return it.
there is a-
We are saying return it to them. That's all.
You lost kindly. See, there are two elements of contribution.
How can you retain that money? It's lying to their credit.
If it will be given to them if they are going to be a pensionable aspect. If they are not going to get a pension from that, it is government's money. Why should it go back
No,
to the
it's not
pension
government-
now?
government's.
It
It's
is.
not government's
It
money.
is.
Election they
So they have to do. Therefore, under this act, either they go back to and part 1 or part 3 as the case may be. Therefore, we are not entering in that question today. So how the entire corpus be given to them?
But how can you retain the corpus?
No, it is only in the event of retirement it will be given to them. So there is a problem. That's why I say this can't be done.
For it.
Not paying pension to them today.
But insofar as the district judges appointed to the High Court are concerned, they will be now entitled to pension as High Court judges.
Therefore, it will be a different pension scheme altogether. So they
Yeah,
can't get
High
a
Court.
pension out
Yeah.
of this.
No, 1 second.
Yes.
For once they are appointed to the High Court, they are entitled to a pension at par with all other High Court judges.
Quite right.
Right?
That in the pension fund they have done so far, government contribution will be given to them as pension today. It can't go as a pension.
But then tell us one thing.
Their contribution they are entitled to take back.
But when they get pension as High Court judges, will that take into account the years of
This
services?
question will have to be addressed independently. You can't hand over the entire corpus to them.
These posts are judges from the district judiciary.
And then they will get it after 12 years, 10 years of service in the High Court. Therefore, today we can't hand over the entire corpus to them. Question. That's why I address this issue before a lot.